Welcome to Knowledge Assist. The Real Estate Regulatory Authority Bill has been passed at the centre and will soon be a reality in Maharastra. But what is the impact of the bill on realtors? Is it positive, negative, or a bit of both? To understand that, we spoke to Mr. Anil Harish, partner, DM Harish & Company, who was gracious enough to spare time and clarify the fears, doubts and uncertainties that are associated with the bill.
RERA is a very important statute because it now attempts to bring together all the parties involved in a real estate development. This is done in different ways. One is that the different parties concerned have to register. A project that is ongoing has to be registered by the promoter of the project. Then an agent also has to be registered, which is something new that has not happened so far. If, for instance, a person is going to act as an agent in respect of buildings which are already completed, where an occupation certificate has been received, then it's no longer at the stage of a project, and therefore an agent doesn't have to register if he's dealing only in completed transactions, in second sales and so on. But if there is an ongoing project, then the builder has to register, and an agent who is going to transact in flats or premises in that building also needs to register. So one important feature is the registration, and we can go into that in greater detail. The second is the fact of an authority being established and a tribunal being established. Under the MOFA, for instance, which is also a regulatory statute relating to real estate, there was not an authority that could take charge of these matters. While the law prescribed that certain things needed to be done and certain things should not be done, how would one enforce them? Anyone who is aggrieved would have to go to the regular civil courts, which are not specialized, and then would therefore have to be in queue for many, many years. So the setting up of an authority here is an extremely important feature of RERA. This will mean that the authority is a specialized authority, it knows its functions, people know where to go rather than having to decide, do I have to go to the small causes court or the city civil court or to the high court? Here they'll just go to the authority. And then above the authority there is going to be a tribunal, so that if the authority decides, anyone who is aggrieved can file an appeal and go to the tribunal. Now, since these authorities are there, which will be specialized, they will have much more knowledge of this, and then I hope that they will be able to establish a system of enforcement of their orders. There are provisions for penalty in the event that a person doesn't comply with the orders of the authority or the tribunal. There are even provisions for imprisonment if a person doesn't comply. But that is only after an authority has decided, and then one chooses not to comply, then you have these consequences. So the first is the fact of registration of projects and of estate agents. The second is the constitution of the authority and of the tribunal. The third, which is very important, is the amount of information that has to be given. All that is detailed. It is set out with many particulars being required. For instance, if a developer wants to submit a particular project for registration, then he has to give the latitude and longitude of the boundaries of the project. Now that may be very difficult to do, because if a project is just, say, on land of 500 square meters or 1000 square meters, it's not such a large piece of land. So imagine a small plot of land, you have to work out what is the latitude of this and the longitude of this corner and this corner and this corner and this corner. It will become somewhat difficult. We'll find more specializations, more professionals who are needed for this, and will need very great precision, but that's the kind of precision that the law wants. So detailing is very important. The fourth thing is the marketing. That a developer cannot market a project unless he's registered, and a real estate agent also cannot market a project unless he's registered and the project is registered. Which means that this information not only has to be given to the authority, but also will be available on site, and anyone who is communicating that information is also responsible. Now, it is not only just the latitude and longitude of a particular piece of land, it is also all the permissions. Today we see many advertisements of pre-launch and so on. But what happens? Has the builder got the IOD? Has he got the commencement certificate? And up to what stage? Because sometimes the commencement certificate is given not for the entire building. Suppose it's a 20 or 40-story building. You may get it for ground plus 5 floors, and then for the next few after you've complied with the conditions. Now the provision is that one will just not be able to market for a project or for flats for which you have not got the permission. So if a builder has got the IODCC for ground plus 5, he can market those, even though his real plan is for much higher. He cannot sell those. He may, whether he can even advertise those is a different issue, because he's not supposed to advertise unless he's registered. And registration means registration for those for which you've got approvals, which means we'll have to see how it plays out. Today, you get a concept drawing or an artist's impression of a building which is going to be 40 stories or 100 stories. But if he's got the IOD-CC for 5 stories only, is he going to show only the bottom of the building and not show the top of the building? Because he can advertise only what he's got approval for, not what he's not got approval for. So there will be a lot of information required, there will be a lot of compliances, and the essence is that they want protection for the consumer. But one feature which the RERA does not have is the fact that permissions are not covered under this. That if the municipal corporation takes time or the environment ministry takes time, then it's not within the builder's control at all. And yet those authorities have not been brought under this, which means that the builder is still groping in the dark. That, for instance, he's got permission, let's say he's got an IOD-CC for ground plus 5 and he wants to construct more. Now, he advertises only for this, but he still has to specify a completion date. How can he say the completion date when he has not got permissions for the next phase of the project, and which is not even going to come now? So he'll really be in a very difficult situation, and he needs to know how much to say, how much not to say, what can he market it at all. In fact, some developers have said that they would rather just utilize their own funds and construct the building completely, get the occupation certificate and then market. But that's not the way it's going to play out for most people. So there will be a great deal of information that is required and a lot of compliances. But let's hope that they can make it workable and in the interests of the real estate sector as a whole, not just consumers, because in every transaction there's going to be a supplier and there's going to be a person who consumes that supply. So it has to work fairly for all concerned, including the estate agent. There are several provisions. Section 2ZM, sections 8 and 9, and section 62, 65 and 66 are the main ones which affect real estate agents. The first is, who is a real estate agent? Anyone who markets or facilitates the sale of a unit in a project will be classified as a real estate agent. Here some questions come up. What about a sub-agent? Does a sub-agent will he also be treated as a real estate agent? Will he have to register or not register? Is it only that the person who's in touch with the customer is the estate agent, or will it be someone with whom he's sharing his brokerage, who's showing people, etc.? Will that include employees of the estate agent? Will it include a website? Because if a website such as yours facilitates transactions, are you an agent? And what if the word facilitation is given a very wide meaning, and if a newspaper carries an advertisement of a project, is a newspaper not facilitating the marketing? So is a newspaper an agent? And does it have to then register? So these are some of the questions that are going to come up. But the main thing is that a person who markets or facilitates or engages in a transaction for a commission or a fee will be treated as an agent under the definition in section 2ZM. Then sections 8 and 9 say that an agent who is going to be engaged in transacting in respect of units in a project must get registered. Once an agent is registered, then he is registered for the entire state. He doesn't have to keep registering for other projects. So if, for instance, He's going to act as an agent for this developer and that developer and a third one and a fourth one. He doesn't have to keep registering. Once he registers, he may register in connection with a particular project, or he may just register on his own anyway in anticipation of tying up with developers. But once the agent is registered, he's got his number, and then he's okay for the entire state. It's different for a developer. It's not that a developer will register himself or itself. The developer has to register each project, because the developer has to give information about each project. The land, the permissions, the size of the flats, the materials that are going to be used, the specifications, the scheduled date of completion, the title of the land, etc. So the developer will have to register each project, but the agent has to register once. Now, the agent will also be required to maintain books of account and records, and the agent can be held liable for miscommunicating information or giving information which doesn't really work out to be correct. Therefore, there is a responsibility also cast on the agent. Suppose a developer, for instance, says, I'm going to complete this project in 3 years. And the agent goes and says, yes, this project is going to be completed in 3 years. If it happens that it's not completed in 3 years, it takes 4 years or 5 years, has the agent miscommunicated? Has he gone beyond his brief? Is he going to be liable? Therefore, it is important for the agent who has to communicate information, because after all, this is the last mile connectivity. It's between the developer and the purchaser. So the agent has a role and he has a responsibility. He needs also to be sure that the information that he communicates to his customers is correct. It's not that he should just make up or give estimates. He should actually get that information documented from the developer. So he should ask the developer in writing, and of course he should see the developer's own registration and brochures and draft agreement. So if the developer has put it in writing, I am going to complete this project in 3 years, then the agent can say that. The agent should not say it on his own. If the agent says the flat is going to be 2,500 square feet and it becomes 2,400 square feet, well, he can have a problem unless he can show that I didn't make up this information. I got this information from the developer, which means that the agent should keep this information should get the information in writing and preserve this. It should not be that the agent should only say, I went onto the website and I saw that these are the specifications of the flats, and well, the developers changed it now, because we don't have a record of the changes or when they were made. So it's important that the agent should get the information in writing and keep updating himself on this. The agent should also communicate his terms to the purchaser. How much is his brokerage going to be? At what stage is it payable? Is it going to be payable when the flat agreement is signed, or is it going to be paid in stages, etc.? Because there has to be precision. It should not be that afterwards one finds that there's a misunderstanding between the two. The agent felt that the commission has to come on day one, and the purchaser feels it has to be paid according to the progress of the building. So he has to be very careful to comply with the provisions and to register. He also has to ensure that the project is registered. He must therefore cite his registration number, like you see in a bill when you go to a shop. You see the VAT registration number there. In the same way, he would have to give his own registration number, and he should give the project registration number. It's only then that he can move on. Now, if the agent does not give information properly, or miscommunicates, or just goes on the basis of estimates and not precision, then he can be hauled up by the authority if there's a complaint, because he can say you misled someone, and therefore it's important for him to be sure that he's got the information so that he can defend himself in case such a matter comes up. I think in fact it makes it a level playing field, because a developer has to mention on his website the names of the estate agents he's dealing with. So if Mr. X is already registered as an agent, for example, and developer A says, I want you to act for me. Then, while the agent is free to act for anyone, if the developer wants to deal through an agent, the developer has to mention the names of the agent. So therefore, the developer will write all the names of his agents on his website. He will write perhaps the names of the international property consultants, and he'll write the names of all the individuals. When he puts up all that information, a buyer who goes onto the developer's website or onto the authority's website, which contains information about the project, will say, oh, I know this particular estate agent, I'd rather go to him than go to another one, or this one is closer, or he seems to be more specialized in this particular area. Therefore, when the names of all the estate agents who are working on that project are given, then it's much more a level playing field. Otherwise, the developer might only say that agency is given to such and such entity. He may not write the names of all the agents. The agent has to be careful of what he says. He should say, I have found out from the developer has informed me that it's going to be completed in 3 years. So that he's really shifted the burden onto the developer, because the developer is the one in control of the project to the extent the developer can be. So it's only for misrepresentation. No one, astrologers do not have to register. So therefore, an agent or a developer who says, I'm going to complete in so much time, well, it may not happen, but the agent cannot be responsible if he's got the information from the developer. Not as of now. Rules are still to be framed, but there's no mention of an exam here. Primarily on account of misrepresentation. And it's not for a particular project, it is just that if he misrepresents to any one client and he gets debarred, then he cannot act for any other project during the period of his being unregistered. There is an authority set up and there's a tribunal set up. This says that anyone who is aggrieved against any of the parties involved, and the parties who can be against whom a complaint can be made are the developer, the agent, and even an allottee, because a purchaser also has certain responsibilities. The purchaser has the responsibility to make payments on time. If he doesn't make payments on time, then the project cannot go on, because it depends on finances from him. So therefore, a complaint can be made against any of the three, which means that, although not specifically stated, but it means that an agent could also file a complaint against a developer and against an allottee, which is why it is important, as I mentioned earlier, for an agent to communicate his fees to the client in advance. And today with email it's much easier to do so, because you may send a letter, a hard copy, and then the client may say, I didn't get the letter. But once there's an email sent, then it's proof that it has been sent. So it can be stated that I communicated this to the client has acted on it, impliedly therefore he has accepted his obligation to pay the commission, and the developer has also accepted his obligation to pay the commission. If they did not want to deal with me after that, then why would they have asked me to show them flats or to show their flats? Now that they've asked me to do it and I've proceeded with the work, that means the commission arrangement has been impliedly accepted, which means that I should be able to file a complaint before the authority. And then if the authority decides and the other party goes up in appeal, then I can also appear before the tribunal to get my claim established. So I think this will help agents a great deal, because today they are reluctant to go to the civil courts on account of the long time that it will take and the burden of proof, etc. But the registration of an agent, therefore, will truly help him and give him a status. It is so, but I don't anticipate that that will happen, because in fact agents and developers all are supposed to communicate the number of their registration number. And I don't think it's going to happen that they don't get it. This is just a way to put pressure on the authority to act within that much time. So I'm sure that they will get it. And in fact, if they don't get it, then they must follow it up and get the number, because without that, it will be very difficult for an agent to establish, or you'll have to prove to each one, well, I gave my application on the 1st of May I didn't get it by the 31st of May, so he'll have to produce all that correspondence. Otherwise, a customer will just not deal with him, or a developer will not deal with him. So while the law says that he will be deemed to be registered, that's not good enough. He must follow it up and he'll get it, and I'm sure he will actually get the number. There are many projects that are ongoing. A project takes several years, 2 years, 3 years, longer than that, depending on the size of the project. Now, when the law comes in and takes effect, then any project which has not yet been completed and has not got the completion certificates will have to be registered. So even though a substantial amount of work has been done, the building has come up to the desired height, but if it's not got the certificates, then it will have to be registered for the developer to do any marketing thereafter. In that sense, it will have an application to projects which were existing, but it won't be retrospective in the sense that if, for instance, an agent had said that the flat is 2,500 square feet and it's actually 2,450 square feet, then it will not be that the agent had misrepresented, because that was a statement that he had made in the past. Any statement that he makes after the registration of the project and after his own registration will be subject to the rigors of this law. But it will have an operation for the future in respect to projects which began in the past. So that's not really called a retrospective operation. It will apply prospectively to ongoing projects. Now, if, for instance, a builder had entered into an agreement to sell a flat to someone and has not given the specification and has not provided the specification that he had said there would be, Italian marble, for example. If the agreement had been entered into earlier and the project has now been registered, and then the buyer finds that he has not been given that marble, for instance, or the project has not been completed in time, then will he possibly be able to take action? Yes, I think he will be able to, because even though that commitment was made earlier, it was a commitment in writing and is a commitment which is there even under the MOFA, for instance, that the specifications have to be given. It's just that now there's more detailing required, but the authority, I think, will have jurisdiction over such matters. Pricing is a result of many different factors coming into play. Supply, demand, interest rates, general economic conditions, etc. It is therefore very difficult or impossible to isolate the impact that any particular factor will have on the pricing as a whole. It could be that one particular factor tends to bring prices down, another one tends to make prices go up. So it's very difficult to estimate that. But there will be some things that will happen. One is that projects will be properly detailed and registered. Therefore, to that extent, there will be less supply in the market, because there will not be cases of pre-launch, etc. So therefore, if there's less supply, I suppose the tendency then would be for prices to go up to that extent. The fact of compliances also, to get all these permissions and to market only after the permissions have been obtained, will mean a delay in the market, in flats being available. So that also would perhaps decrease the supply and therefore tend to increase the price to some extent. On the other hand, the fact that a developer has to specify the period within which he has to complete and must stick to that, otherwise he can be exposed to penalties, will mean that if he begins a project, then he will complete it on time and he will not begin multiple projects without having the capacity to complete. So therefore, the fact that the buyer will have more confidence may mean that more buyers come into the market and therefore things move much more smoothly. The impact on prices is very difficult to determine, but the impact on the market after the initial transition period and after everyone gets used to it, and I hope that the authority is actually very practical in its dealings. It understands the issues and then takes decisions or makes rules and regulations. I hope that they are practical. in which case the sector should really become a transparent sector. No one should be able to take advantage of the others. The authority has to be set up, then rules have to be made and regulations have to be made, and the tribunal has to be set up. The maximum period of time within which it has to be made effective under the law is 15 months from 25th March 2016. We hope that it will be set up well before that, because the Maharashtra government, as you know, had been very proactive. They had promulgated the Maharashtra Housing Regulation and Development Act, and that then was stillborn. It was not really given effect to. But since they've done a lot of work, hopefully in 6 months or so, they should be able to set up.